Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We do this community conference call every other Thursday. Today is Thursday, April 28th. I have a list of questions. I did not mark any question as a frequently asked question. So we'll go over the list of questions. I want to begin with a caveat. Please make your questions shorter. I have a limited amount of time here, and I would like to cover as many questions as I can, providing people guidance as best as I can. Note that this is not a substitute for a detailed consultation, and as you entered the conference call, you heard the disclaimers. They apply. We do not establish attorney-client relationship here, and the information cannot be guaranteed. It's based upon what we know off the top of our heads and based upon the information we've been able to develop in the short time we have together. Okay, now let's make sure you can hear me okay. So just 1 second, let's confirm that. All right.
The conference is now in conversation mode.
Could you please confirm if you can hear me okay? Can you hear me?
Yes, I can.
Okay, very good. Thank you. Thank you very much. Okay. All right.
The conference is now in presentation mode.
Let's get started. So the first question is foreign equivalency certification for H-1B RFE. So what happened was I was reading through these questions. Some of them I've been able to read just before the conference. So what happened here was you finished the master's degree coursework, but you cannot get the proof of it because the university registrar, they are short of staff, etc. Since the petition was selected in general cap, can I apply with just my bachelor's? See, the problem is they enrolled you in the master's cap. So if you try to apply in the general cap, I think it will be denied. I think you'll have a denial in your hand. So I think you are better off applying for, this is my feeling, for the master's degree cap or the master's degree petition, and attach an affidavit saying that I've tried to get my coursework completion certified by the registrar, but they have a staff shortage, etc. You need to talk with your lawyers. I think that's the way to handle it. I don't see how else you can manage this. But I think if you apply under the general quota, you will either get the petition rejected or denied. That's what I feel. Okay. *5. If you have a follow-up question on this, press *5 on your phone. Okay, no follow-up question. Let's go on to the next question. Options if green card EAD expires while renewal is in process. So son is in the senior year of bachelor's in industrial. Internship applications in multiple places, but the employers reject because the green card EAD is expiring in April. You've applied for the EAD, but the employers are not accepting the 180 auto extension. Well, that's kind of illegal. In my view, it's referred to as document discrimination. I'm not sure if the employers are receiving good legal advice. But in any case, the bottom line is if they are not, they are not. Is there any solution to this issue? Is F1 OPT EAD or CPT an alternative? I think CPT could be an alternative, but yeah, I think so. I think CPT could be an alternative. How about OPT EAD? But that's also going to take time, right? That's one thing. And the other thing is to try to expedite the green card EAD simultaneously with the CPT by requesting the government that, look, we are losing employment opportunities because of this lack of EAD in hand. I think it's worth a shot. That would be one thing. And of course, simultaneously enroll for for a CPT EAD type course. *5 if you have a follow-up question on this. Press *5. Okay, let's go on to the next question. So this one is EB3 has been approved and has been current for more than 1 year. I'm currently in India and I don't hold an H1 or L1. Am I still eligible for cap exempt H-1B? In my view, yes you are. For how long? See, the thing is, once your I-140 is approved, I suspect that you could be eligible for forever. That's the way I see it. Okay. Now, if you had an approval within the last 6 years, then for sure you should be entitled to cap exemption, even if we just read the law and don't read into all the policy nuances. And the way the government was calculating the 6 years was as follows. So let's say your H-1B was approved from 2016 to 2019. So within the last 6 years will be counted to 2019, not to 2016. That means you would be within 6 years beginning 2019 when your H-1B expires. So that's the way I remember them doing it. Now the fact that your dates are current and you have not applied for a 485, etc., that can be, if that can be adequately explained, you will be entitled to a 1-year extension right away. And you should be able to repeat that performance or come into the United States and look into filing a 485. But what if you cannot file the 485 because you're not with that employer or you're outside the United States? I think that's a good explanation. You should try. I think you'll get the H1. L1A blanket from Canada? Well, depends upon the L1Bs are always uncertain. L1A is much more so. I think L1A can be easily, we can predict when the L1A is going to work for most cases. So yeah, it's certainly possible. And if you have a follow-up question, press *5. I have somebody raised their hand just now. Area code 210. Area code 210, where are you calling from?
Texas, Rajiv. Thank you.
You're welcome. Which question are you following up on?
So what you just mentioned, so those are my questions. So my question is, so you said I'm still eligible even though my dates have been current for more than 1 year, right?
Yeah, the law says, the law says if you have an adequate explanation for why you have not filed a 485, we will, actually hang on one second, I'm sorry. You're not under that category. You should actually be entitled to, I suspect you could get 3 years extension. That's what I suspect. Okay. So at the very least, you should get 1 year. I'm trying to remember the law. So the law says if you have a 485 pending, you will not get an H-1B extension except for 1 year. I think yearly extensions. And if you have not filed your H-1B for the past 1 year, then you must have an explanation why you have not filed the 485. The law does not say anything about people outside the US from what I remember. I am quite sure you should be able to get 1 year extension. Okay?
Okay. Okay.
Good luck. You're going to have to hurry up, sir. I have a bunch of people waiting on you. Go ahead.
Yes, sorry. So what I want to ask is, so the fact that I've been outside the US, will they take exception to the fact that, I couldn't file I-824 or, take the consular processing, route, meaning go ahead with the adjustment of status through consular processing? Will that be a grounds for rejection of the H-1B by any chance?
I am confined in my answer because I don't have the laws in front of me. I'm speaking from general knowledge. I'll have to review. I am fairly certain you'll be able to get 1 year extension and on an ongoing basis. That's my opinion. But let your lawyers look into the details.
Okay.
I think it's definitely worth looking into, and I think you'll qualify. Okay?
Okay.
Good luck.
Thanks, Rajiv.
You're
And
welcome.
the fact that, if I'm in Canada, that shouldn't change anything, right?
That does
in this
not
case.
change anything.
Or
No.
if I'm with a different employer.
That makes the explanation easier.
Everything.
That makes the explanation easier.
Okay.
Doesn't
So
it?
everything that you said, the fact that I'm eligible for H-1B, at least for a 1-year extension, that's the case with any employer, right? So a new employer could apply for a new H-1B using the I-140, right?
That's my belief.
Not
Yes,
just
sir.
for current.
That's my belief.
Okay.
1 year or
Okay.
maybe 3 years. I don't remember which one of the prongs would apply to you, but you definitely have a good reason you've not been able to complete the green card process. Okay.
Okay.
Good luck.
Also,
Okay, folks, I don't have unlimited time. Remember that. You want a consultation, set up a consultation with our office. I'm trying to help as many people as I can. Will my H-1B visa be cancelled if I enter the US on a B2 visa from Canada? So if you look at the standard operating procedures of the State Department, from what I remember, they seem to suggest that before they even take your application, let's say for B2, they should cancel the existing H-1B. As a practical matter, they don't do it. I'm not sure why, but as a practical matter, they don't do it. So your question is, if I travel to USA on a B2 visitor visa, will it automatically cancel my current H-1B stamp? And the answer is no, it should not. Okay, but at the same time, technically they should have cancelled the H-1B already, but they don't do that for whatever reason. But I'm not sure why you are so keen on saving your H-1B visa stamp. It doesn't really mean anything. So I'm not sure why you are so, like I said, keen on keeping it. But to answer the question that you have asked, traveling on B2 should not cancel your H-1B visa stamp. Okay. *5 if you have a follow-up question. *5 if you have a follow-up question on this. Okay, area code 226. 226, where are you calling from?
Hi, sir. I am calling from Canada. Unfortunately, the response, I couldn't able to hear you at the same time. So I just wanted to know quickly that there won't be any issue if I attend and get the B2 visa and enter the States, even though I have H1, and it won't impact on my 140 when the dates become current if my employer applies through consular processing?
It should not. It has zero impact on your green card. And I said to you, you can listen to the recording later. I'm recording this anyway. I said to you that I'm not even sure why you are so keen on keeping your H-1B. But just traveling on a B2 does not cancel your H-1B. And no impact on your green card. Okay?
And can I also renew my H1 once I get the B2, like in 2023, if my employers wanted to do the paperwork?
You have a fundamental misunderstanding about the nature of H-1B. So I don't have enough time to go over it. Suffice it to say, keeping it alive through a visa does nothing for you. You can let it go and still renew it. So we'll have to deal with that another time. But I think you are putting too much emphasis on your H-1B visa. It's not doing anything for you. Okay? You have a fundamental...
And there won't be any impact on visitor visa, right? Okay.
The H-1B visa should not have any impact on your tourist visa, no. Visitor visa. Okay?
And green card also. Okay. Yeah, that's the main thing. Okay.
Yeah, green card absolutely immune. No problem at all. All right?
All right. Thank you.
Good luck. Oh, one thing I want to add, they can, of course, refuse to give you a tourist visa because you have a green card going. Okay? But that's totally...
Yeah, that's what I thought. The intent doesn't justify. Yeah.
Yeah, they can. But people have received tourist visas, even when their green cards was pending. I deal with it all the time. So I think it depends upon the facts of the case. I suspect somebody like you should be able to get a tourist visa. Okay?
Does it have to be B2 or B1, B2?
They usually give a mixed use B1, B2.
Because in the application there are two different categories.
Yeah, you ask for
when I,
B2.
put the interview.
You ask for B2, but the normal
Okay.
procedure is again, unless they've changed something, the normal procedure is to give a mixed use B1, B2.
Do I need to carry a letter from my friend saying that he is inviting for
You do
a
not.
valid reason for justifying?
Not here, not really. No. No letters are required.
Got it.
Good luck.
Thanks, sir.
You're welcome. Okay, let's go on to the next question. Oh my God, this was a complicated fact pattern. Okay, are you on the call? AMP 123 question number 6? Because I'm just going to give you the bottom lines and you can apply them to your case. Okay, good. You are here. I think you're calling from Connecticut, right? Area code 203, right? Hello?
Yes, hello Rajiv sir. Thanks for helping us with Unity.
Okay, so let me give you the bottom lines and then you can apply them to your case. So what I understand of Child Status Protection Act, it works like this. It will subtract from your son's or daughter's age the time that the I-140 was pending. So that one we know. Okay. So if you have an EB3 I-140 and EB2 I-140, we'll consider the time for each one separately depending upon which track you are going through. If you file green card through EB3, we will look at how long the EB3 I-140 was pending. If you file it through EB2, we'll look at how long the EB2 I-140 was pending. When you interfile, first of all, when you file based upon dates for filing, your child is not protected. The final action dates must become current before he or she turns 21 using the age, deduct from age I-140 formula. So, rule 1, we'll deduct from the age the time the I-140 was pending. Rule 2, we will go with whichever track you want to follow. Rule 3, EB2 or EB3. Rule 3, it is the dates for final action dates that must become current. Dates for filing does not protect him or her. Okay. Now, if I'm protected under EB3 and I move to EB2, my child could lose their CSPA protection. So those are the 4 or 5 rules. Does that help you understand your situation? Because your facts were too complicated.
Yes,
I just don't have time to go through all of that.
Yeah.
Does that help? Ma'am?
Yes. But I have a question on this.
Yes.
May I?
Mm-hmm. Sure.
Yeah. So I did not add my son when I filed based on filing date in EB3.
Mm-hmm.
However, now EB2 final action date become current for me.
Mm-hmm.
If I interfile, and I will have to add my son's 485 application, new one, right, in my interfile together.
Yes.
So does it lock the age?
Does it what?
Does it lock my son's age?
Okay, so now again, not knowing your facts, I'm just going to give you the generic statement. So let's say, forget about interfiling. It doesn't really matter. You're moving your 485 to EB2. Okay. At that point, your son is still under 21 according to CSPA calculations, and you file his 485. When you asked for the interfile, his dates for final action or final action dates for current, that should lock his age.
But if I don't receive a receipt for interfile, how would it be confirmed for me that his age?
Yeah,
is
but you are
locked
filing
and
you are filing his 485, right? You'll get his receipt.
Mm-hmm.
When you are filing his 485, you'll get his receipt, so you're fine.
So my concern here is I will receive his receipt for EB2 based on EB2 485 filed for my son.
Mm-hmm.
But in case if USCIS does not consider or does not accept my interfile and they process my 485, they approve my 485 based on EB3, then what happens with my son's file, which I have filed based on EB2.
Okay, now this is a question that is not answered anywhere in writing or orally in any conference of any USCIS calls. So if your own I-485 fails, what happens to your son's I-485? They would, of course, not allow that to go forward. But what if your I-485 is approved under the old application? This is my guess. My guess is if his CSPA age is not protected under EB3, then he would not be able to take advantage of it. Now, the way I would deal with this situation, and I can't go into all the details, talk to your lawyers, I would actually consider filing multiple I-485s. Because your son's age protection is very important, I would consider, instead of interfiling, filing a second I-140 for you under EB2 category, and an EB2 and an I-485 for your son under EB2 category. And because the final action dates are current, I would probably also file a 485 for him under the EB3 category.
Got it. Okay. So
Take
can
no
I
chances.
file new 485 also if I have started using EAD and advanced phase?
That doesn't matter. They have made that clear. That doesn't matter. Okay.
Okay. Last question, sir. Please.
Yes, ma'am.
So if my son, he is currently on F1 visa, so if I add his 485 file, still he can continue and maintain F1 visa?
You should listen to the frequently asked questions, audios and videos we have. I have discussed this issue in great detail. Sure. Bottom line is, as long as he doesn't travel, he should be okay. But if he travels using advanced parole, etc., then he can go to school on his 485. Okay. Good luck.
Good. Thank you.
You're welcome. Bye-bye. Yes, some of these questions can get into very complicated territories. And Rahulji, I think your question is under that category as well. I want you to set up a consultation for us. I'm not able to answer this question. But let me see if I can. Because when I started looking at it, I got all confused. I don't know what you're asking me. Let me try again. Currently on H-1B, filed for I-485 in November 2020. You downgraded. Okay, got that. Received 485 EAD and AP, never used it. Okay. I-140 approved in both categories. Okay. Then re-entered USA on H-1B visa stamp, but only a few months left on current. Okay. Never interfiled. Okay, so you have two separate cases. Rahulji, are you here? Is that you? Well, let me just see. Area code 608. Is that Rahul?
Yes, sir.
Oh, good. Okay. So, do you have two 485s pending or one 485 pending?
One 485, but two 140s.
Yeah, that I got.
And the one 485 was.
Achha.
And 485 was for EB3.
The 485 was for the EB3 or the EB2?
EB3, because I had to downgrade. Downgrade kiya tha.
Oh, so when you downgrade, did you downgrade it as an amendment or a new I-140?
New I-140.
Oh, good. Okay.
Not as amendment.
Suppose I don't renew. Okay, that's why I was like, I am not sure what you are talking about. Okay, suppose I don't renew my current H-1B with employer A. Is employer A EB3, employer B EB2? Is that what it is? Do you have two employers? Right now, is there one employer in the picture or two?
Right now, it's only one employer.
Ah, okay, got it. Got it. Got it. No, got it. Okay, so that's why when I started reading this question, I actually had a headache. I was like, I don't know what we are talking about. Okay, so if I don't renew my H-1B and I take 3 months break, then I resume with the same employer A on the same full-time job, but now using EAD, or a new employer B for a similar full-time job using EAD. Now your 485 has been pending more than 180 days?
Yeah, it was filed in November 2020.
Okay, so both A and B are possible. Okay. Also submit 45J in both cases. I would not do both cases. No, I think that becomes a little complicated. Okay.
No, one of the two.
Oh, one of the two, yeah. So you can do either or in both these cases, as long as it is either or. You don't file two 485Js.
Okay.
Okay.
Sure.
And your understanding is incorrect. USCIS does not primarily use SOC code. They look at the entire job.
Okay.
Okay. So that's an incorrect understanding. Can primary H1 applicant have an H1B changed to a new employer petition? Can a primary H1 applicant have H1B changed to a new employer B petition pending when the H4 is traveling back? Oh yeah, absolutely. Absolutely. Because what happens is, as long as the H1 is maintaining status, whether it is in a transfer, AC-21 portability, H4 can travel and re-enter using her visa, no problem at all. Okay?
Okay. Two small questions.
All right.
With respect to question 3, in this case, if I'm doing change of employer and that's pending, the H4 visa would still be connected to my current employer.
H4 visa is not connected. H4 visa is connected to you.
Oh, it's not. I see. You're right. You are right. Yeah. Sahi baat hai aapki. Right. I missed that.
Right.
The other question, and I'm coming back to question 1. So, you never use EAD, like technically never use it, just have it and put it in a box.
Right.
And if you, let's say, don't apply to renew your H1 and let's say take, for example, a break, would it consider that, I mean, I know you would be in that period of authorized stay, jaise aapne last time bola tha.
Right.
Would that be a problem with respect to GC?
Not at all.
Because then you are using EAD and that's the first usage of
No, not at all. There is no issue. The only thing I would have been concerned about is if you joined back the employer A, they could say, well, did you really want to work with them permanently? I mean, they never ask these questions, frankly. As long as you have the intention to join and stay there on an indefinite basis, whether you join A or B or C or D, or even not even join, just produce a letter of employment, that is good enough for the green card. Okay?
Correct. And then one small question about question 2.
I'm going to have to move on, Rahulji.
You just said
I'm going to give you 10 more seconds, finish it up. Go ahead.
Do they also look at the salary differences?
They do.
Okay. Or same and similar job?
They do. But it's not a primary consideration. Okay?
Okay.
Good luck.
Okay. Thank you, sir. Thank you so much.
Bye-bye.
Sorry I couldn't connect fast.
That's okay. One last
Have a good day.
One last point about the salary. Salary can also depend upon, sometimes you get more benefits. Okay, that's not considered to be salary, but that's the reason you took the job. Or the job is so attractive, it has much better promotion potential. Or the job is in a different geographical location. You can't expect that the salary in a little village in Illinois is the same as the salary in San Francisco. So there are all these variables. Okay.
Correct. And they consider all that. I mean,
they have to. They better. Otherwise, we'll take them to court. Okay. Good luck.
Thank you, sir.
All right. Bye. Yeah, Rahulji and I have been talking for years. Concurrent enrollment for F1 students. So what is this? Oh, you want to go to 2 universities. Okay. So one CPT and one regular. Okay. So here is the problem. Okay. I can tell you, I don't know what the exact law on this is, but I can tell you, typically universities will allow you to enroll concurrently while you're on F1, as long as, and this is something I'm speaking from memory, okay? Double check this. As long as you are maintaining full-time course load combining the two schools. And many universities will not allow you to carry your CPT credits to a different school. And if I remember correctly, if you are doing CPT, they won't let you enroll concurrently. There might be a bar against that. Double check these things. So it may not be possible what you are thinking. This is what I just remember off the top of my head. *5 if you have a follow-up question, *5. Okay, so next one, question number 9 is STEM-OPT laid off, whole department got laid off on 12th. I got paycheck for this month on 30th. And then you have a severance package, ends on 31st May. 15 paid time off days, which I can still use. Unemployment days remaining for me total 100 days. So out of the 150, you use some during OPT, I guess. Okay. So what is this is a very interesting question. What is the date the unemployment starts? Is it the reason I laugh is because this is such a weird question. We run into it in H-1B situation. So I'm going to tell you the law on the H-1B side. I don't know if the government thinks of it the same way. I have never seen an explanation of it. You can again check with universities if they have seen this pattern before. But in the H-1B setting, there is the theory and there is the practice. First of all, where theory and practice are the same as this. It is the pay period that is covered by the check that matters. So if you receive a check today, but the pay period covered is only till March 30th or 31st, then you're not covered till today. You're only covered to the extent of your pay period. This is where theory and practice in H-1B is the same. Now, severance pay, this is where things get weird in H-1B. Government said severance pay is not really regular pay, at least that's the theory. In practice, they have allowed severance pay to carry forward your status, especially if the severance pay is equal to greater than your salary, regular salary. Okay, so that's the second situation. I'm assuming the government will look at OPT the same way. Now, the third thing that is interesting is your paid time off days. So, paid time off days, I think, can be argued as regular status. Why? Because you have worked for that already. You see what I'm saying? So you've worked for it already and you're getting the benefit now. So that's just like a regular job. I would suspect three things that I just talked about. One is quite clear. You should be able to use your paid time off as working days, especially if they are covered in the paycheck. Okay, or there's a letter from the employer that says they're giving you 12 days paid time off. That should be available. Okay. It is also, if we apply the H-1B rules, then it is the pay period that matters. That's how you will be covered. Okay. I don't know what else your questions were. Will there be 30th? Only get push the unemployment. This employer has also filed for my H-1B, which was not selected. Can they still sponsor my H-1B? Absolutely. Absolutely. How will that work? Well, the way it works is it doesn't matter if you are in USA, India, Switzerland. The H-1B lottery can be applied for people outside the United States or even another status. That's not a problem. To maintain status, what things should I keep in mind and what are my options? Okay, that's a very, very long discussion. Okay, but suffice it to say that you should try to get back onto your STEM-OPT extension job as quickly as you can. Otherwise, you would be out of status. You can try these relatively flimsy and undependable things like a tourist status, applying for a tourist status. Not sure what that gets you. The real good option is to get back to work. That's what I suspect. Okay. If you're here, press *5. Press *5 if you have a follow-up question. Okay. So you'll listen to the recording. Okay, so this is another situation. I have written about it in my, if you go to Google and just type Rajiv, that's spelled RAJIV SKHANNA, Khanna or Khana, Economic Times, you come to my author page. And I've covered this issue there, the cancellation of the B1, B2 when you leave during an extension, etc. Okay. So let's see. You had a previous question, so you already know the discussion, good. B2 was cancelled as an overstay. Okay, so that's wrong. I told you that, right? And that should be in the frequently asked questions. The standard operating procedures of the State Department do not allow this result. This is called Section 222G. They should not be applying it to people who travel out before a decision is made on their extension application. You haven't heard from the congressman yet. They can reapply for a B2 visa. My concern would be, it would be a stronger application if they can wait 1 year after they left the United States. Why? Because even otherwise, if you visit the United States too frequently, the government can take an objection to it. If I were you, I would wait to get this thing cleared through the congressman's office. I think their current visa should be held not to be cancelled, but I think they should still not travel to the United States until approximately 1 year after they left. If they come back too soon, their entry could be declined by a CBP officer, even if the visa is considered to be valid by the consulate based upon the pursuit of the congressman. Okay? So bottom line, if you have to apply for a new visa, wait 1 year. If they want to travel, wait 1 year. *5 if you have a follow-up question on this. *5. Okay. So parents are visiting and they want to travel to Mexico. What should we carry? An extension. See, you also need to, Manishankar, read my article on the Economic Times about the problems people are facing when they extend tourist status. So if possible, avoid it. Okay. If you go to Mexico, you're not going to get the same time back. In other words, they won't add another 6 months, not normally. And what would they have to carry? The same thing they carried when they came to the United States. Okay. By the way, I do know cases where people got new 6 months when they re-entered. That's unusual. That's not the normal thing. Okay. Now, they cannot travel if you file the extension. Then their extension is deemed to be abandoned. And nobody really files extensions 45 days before I-94 is expiring. I have never done it. We always do it at the last moment. There seems to be no problem with that. *5 if you have a follow-up question. If you're here, press *5. Okay. 203, I guess, Connecticut. Go ahead, Connecticut.
Hi, Rajiv sir. Thank you for your help. So my question here is, so are you even suggesting it's okay to file extension, or you are saying to avoid?
Okay, I thought I was pretty clear. I would say avoid extension unless completely necessary.
Okay, because it can create an issue in the future.
Exactly. It's creating these weird issues that are not really legal. The government is wrong in their interpretation, but they are the government. It is easier not to fight them than to fight them.
Okay. And one more question. Let's say if I decide to file right after our trip, we come back, we file an extension, and if they leave before their biometrics, is that okay?
That's what I just explained. Now, if you listen to our frequently asked questions and you read my article, it tells you that government is actually saying, even if you leave before the decision on the application, we will cancel your visa under Section 222G. And I said, no, that's against your standard operating procedures. Your SOP says if you leave before a decision on the application, 222G does not apply to you. Okay? But they are applying it, so just keep that in mind. Depends upon how much hassle are you okay with. Okay.
Okay. So basically, if a decision is not made and it's pending, then there will be no 221G, right?
Even then, they are applying the 222G. That's the problem.
Oh, that's the problem. Okay. Thank you.
Okay.
Thank you. Yeah.
Good luck.
Thank you.
All right. Bye-bye. Area code 608. Where are you calling from?
Sir, this is Rahul again, and we just talked. And I'm not talking about my previous question. I just have one quick question about this current question that you just answered.
Okay.
In general, if someone's tourist visa is cancelled or any visa, how does that person come to know? Is there a way to find out?
They'll get an email. Our clients have been getting emails.
Okay.
So they
from
do,
the Department of State.
From the State Department. What I actually did, first time I saw that email, I actually went into the meta text of the email. I tracked it back to the servers. I'm half a hacker myself. I confirmed it was coming from the State Department. Then I checked with our contacts and they said, yes, we are sending emails like that.
Okay, but there isn't like a number you can call or send out
you can send them an
ask this
email.
to someone,
You
right?
can send. You can't respond to that email, but you can send them a separate email saying this is the email we've received. Can you confirm it? Okay.
Okay, but you will get an email in there.
You should.
Okay.
That's what I've seen two
Okay.
cases like that. One of them actually we are fighting.
That was
Okay.
Oh,
All right.
okay. Thank you. That was it.
Good luck. Okay. Area code 314. Where are you calling from?
खन्ना साहब नमस्ते सवाल दाखिल नहीं कर सके बैक ऑफ द लाइन कोई 2-3 मिनट मिल सकते हैं साहब
At the end of the line ਜ਼ਰੂਰ ਮਿਲਣਗੇ ਜਨਾਬ ਅਜੇ ਤੁਸੀਂ ਵੇਟ ਕਰੋ I'll get to you for sure. Okay.
ठीक है बहुत शुक्रिया
You're welcome.
मैं वेट कर रहा हूं
हाँ जी, thank you. Okay, so then we come to, we just finished this, right? Yeah, Manish Shankar. So the 180-day portability rule and EAD AP from EB3 downgrade. Okay. So I've got a priority date which is 2013 in EB2, same employer since 2010, filed EB3 downgrade, got EAD AP. I have not used my EAD AP. After EB3 dates retrogressed, filed a new 485. Good. USC announcement came in 2022 about interfiling. So I filed a 485J. That's fine. Now I have two separate EB2 applications. I have a job offer in same similar category from another employer. Okay. So this is again very complicated fact pattern. I don't have the time to go through the entire fact pattern. I can tell you, are you here by the way? Whose question is this? Atul K, are you here? Press *5 if you're here. Okay, I'll give you the general, oh good, you're here. Area code 608. Area code 608, where are you calling from?
Texas, sir.
Okay, so let me give you the general law and see if that helps answer your questions, because the question is kind of a very extended fact pattern. So bottom line is this. Let's begin with your I-140. You have two I-140s based upon the same PERM application, correct?
Yes.
Okay. So when you applied for the downgrade, did you file for an amendment or a new petition?
A new petition.
Good. That means you have two surviving I-140s. Now you have a 485 with your EB3 and you filed another 485 with your EB2, correct?
Yes, that is correct.
Okay. So now here is the interesting thing. The way I see it, the AC21 portability on your EB3 started when you filed the 485 and the I-140 was approved. Okay. The
Is it not after the 485J?
No. Let me come to that in 1 second. The part that is clear.
Okay.
when you filed your EB3 I-485 and the I-140 was approved, 180 days would have started from the date of the 485 filing. On the EB2 side, when you filed the 485 on an approved I-140, 180 days started. Are you good so far?
The 180 days started from the day 485 was filed, right?
Exactly. Okay. So you are safe on the EB2 side because you have a AC21 running already 180 days there. Now you have another EB3 which is secure until you say, oh, by the way, I want you to move this 485 to my EB2 I-140. First of all, the government should deny that request. Why? Because you already have a 485 pending in that category. But even if they don't, I don't see why there's a problem because you have AC21 running already on the earlier filed 485. So I think you are pretty safe. I think there was a little bit of a mess made in your case. There should have been no interfiling necessary.
So that the 180 for the one for the original EB2 was filed 5 months back or 4 months back, so it's not 180 days yet.
It will be soon, right?
The other one was filed in October 20.
Yeah, so it will be 180 days soon, even for the second one. Remember one thing, you are not required to hold that job for 180 days. It is only required that your I-485 remained pending for 180 days. And if the employer doesn't revoke your I-140 and it goes through another 2 months, 3 months, then you are safe. So the idea is you do not have to hold that job for 180 days. Your I-140 remains unrevoked and your 485 remains pending for 180 days. That's what we care about. Does that answer your questions?
Yes.
Okay.
In case of a switch, the original one or the downgrade one that was filed in 2020, will that is there some chance that it will get cancelled? So in other words, if
I don't know.
EAD for the one that
I don't know, because I don't know why you would have filed an interfiling of the 485 from the EB3 over to EB2 when you already have an EB2 485 pending. So I'm confused about that, but in any case, because that has been done, I don't know what happens to the EB3 485. I have no idea. But the EB2 485 will secure you once the 180 days are over.
But so if the because if I switch, I'll be using the EAD that came from the EB3 485 filing.
I think one thing to do is, and I'm going to only spend about 10 more seconds with you. I've got to move on. I'll give you a practical suggestion. Because this is such a weird situation, if I were you, I would have my lawyers call the USCIS customer service. They'll be kicked up to the next level support, which is an actual adjudications officer. Discuss the situation with them. One thing that makes sense is to simply withdraw the request for interfiling, saying it already has a 485 attached to it. It doesn't need to be interfiled. Okay. That's the only thing I can see happening, but check with the USCIS what they recommend, because this is an odd situation. Okay. I'm gonna go. Good luck. Okay, so next, job change impact on spouse's H-4 EAD while monetizing YouTube account. Receiving royalties while on H-1B. So we've discussed this many times before, Rohan. I am not at all sure it is legal for you to, you also written a book on coding. I'm not sure it is legal for you to receive money even from an activity like a YouTube channel and writing a book. I know that for college professors and researchers, there has been and I don't remember exactly where I saw it. I once noticed that USCIS said they'll let it slide because that's such an integral part of their job, writing books or articles, etc. And I had a case where a professor got paid for speaking at a conference, some industry conference, and they were confused whether they should keep the money. And we had a discussion with the USCIS, and they said, yeah, you can keep the money. It's not a violation of your H-1B because it's a part of your academic activities. However, in a case like yours, since you are not really engaged in those academic activities and the YouTube channel has nothing to do with it, this could be a violation of your status. What income sources are permissible? So we've discussed this many, many times before. Just go to our frequently asked questions, read through them. Going back 10 years, 15 years, I've not had a reason to change my mind about my opinion, which is passive income is okay, active income is not. Active income is anything for which you did any amount of work. So even if you made a phone call, theoretically it could be active income. So when you're writing a book, definitely active. When you are maintaining a YouTube channel, I think it's active. Now, unless USCIS makes a policy exemption on these cases, I think you'll be violating your status. Star 5, if you have a follow-up question. Star 5. Okay, we are coming to the end of our question, then we'll start with the new questions. Whoa, another long fact pattern. I'm not sure I'm going to be able to cover this, guys. Such a long fact pattern. So I-140 for PERM-based green cards. I don't know what this is. I am working for employer B on H-1B. I have an approved I-140 from employer A, previous employer. My H-1B extension was done using approved I-140 from employer A. I've left the job 2 years back. Current employer is pressurizing me to apply for a new PERM and I-140 through them. They're saying I-140 is a location, employer, and job-specific petition, and also the company's policy. Well, there's nothing in law that says you can't keep extending your H-1B through the old I-140 as long as the I-140 stayed approved for 180 days, and at least one of those 180 days was on January 17th, 2017 or later. Okay? But if they want you to file, that's a company policy. Question. Will my I-140, which stands approved, get invalidated, cancelled? No, it does not. You can have 10 different I-140 approvals. Each one of them can survive. Second question. If my current employer raises a new PERM, the priority date will be the same. Yes. Will that rule of staying 6 months with the current employer post I-140 apply? There's no rule that you have to stay with any employer. The only rule is that first of all, I've mentioned this many times before, your priority date is yours to keep the moment your I-140 is approved. And even if your employer revokes the I-140 the very next day, you still keep your priority date. But the right to extend your H-1B attaches only once the I-140 remains unrevoked for 180 days. You don't have to be employed with that employer, it's just that they did not revoke your I-140 for 180 days. Then you can keep extending your H-1B beyond 6 years with any employer. These are two different rules. Nisha, if you're on the phone, have a follow-up question, press star 5. Okay. Anyone who has any question, press star 5. I'll answer in the order that you logged in. Okay, I have 6 questions so far. 7, 8, okay, 9, oh, okay. All right, 9 questions. I will not take any more after 9, folks. Okay, so let me begin first with Texas, area code 469. 469, go ahead, I can hear you.
Yeah, hi. So I'm an F1 visa and my lottery got picked by an employer A this year. And I got a new offer with employer B. So can I switch my companies after H-1B approval?
No.
Before October 1st?
No.
And how can I retain my H-1B
No.
company B?
Okay, I got the question. I've dealt with it almost every call that we made. So if you look at the frequently asked questions, they tell you this. this is the current thinking of the government, right or wrong. I think they can be challenged on this. Their current thinking is, if you change employers before October 1st and your old employer revokes your H-1B before October 1st, you are back in the quota. Only way you can change is if the old employer says, no, we won't revoke your H-1B. Then you are okay. But if they revoke before October 1st, you are back in the quota. Okay? Ma'am, you're going to have to say yes so I can go to the next person. Yeah.
Yeah, one of the videos which you made, you said that technically if I don't work for them, they have to revoke or withdraw the petition after...
Not until October 1st. Them, right? They have no obligation to do so until October 1st. Because their obligation to pay you doesn't start till October 1st. So they can hold on to your H-1B, no problem with that.
So even if I get an approval, let's say I'm switching on the month of September, they should be in a position that they are not revoking, only then I can switch my
if they asked me, if I was the corporate lawyer, if they asked me, I would have said, yeah, you have no obligation to start paying until October 1st. You can hold on to the H-1B. October 1st, you can send a letter saying, we revoke.
Okay.
Okay.
And what about the employment pay stubs which I have to provide as proof after October 1st?
I'm going to let you talk to your lawyers about all. I'm going to let you talk to your lawyers about all that. Okay. That's not a problem here. Okay?
Sure. Thank you.
You're welcome.
Thank you.
Okay. Guys, please be quick. Be mindful there are other people waiting. So I'm going to go to Missouri next. This is area code 314, it looks like. 314, go ahead, please.
Yes, Khanna Sahab, बहुत धन्यवाद कि तुसी कॉल लई जे मेरी सवाल नहीं मैं कर सकिया सज्जन ते मित्र बहुत लाइन च लगे ने मैं दरिया नु कूदे जो क्विक बंद करांगा ते मैं गल करांगा बड़ी और बड़ी सर जी L1 A ਦੇ ਉੱਤੇ ਐਂਟਰੀ ਹੋਈ ਹੈ ਠੀਕ ਹੈ ਨਾ ਜੀ ਲੀਗਲੀ ਐਡਮਿਟਡ ਐਂਡ ਇਨਸਪੈਕਟਡ ਸਰ ਪਹਿਲੀ ਐਕਸਟੈਂਸ਼ਨ ਹੋਈ ਦੂਜੀ ਐਕਸਟੈਂਸ਼ਨ ਹੋਈ ਸਰ ਦੂਜੀ ਐਕਸਟੈਂਸ਼ਨ ਦੇ ਦੌਰਾਨ ਸਰ ਜੀ 140 ਫਾਈਲ ਕੀਤਾ ਠੀਕ ਹੈ ਜੀ RFE ਆਇਆ ਉਹਦਾ ਜਵਾਬ ਦਿੱਤਾ CIS ਨੇ ਗਵਾ ਦਿੱਤਾ ਉਹ RFE ਠੀਕ ਹੈ ਜੀ ਜਦੋਂ ਟਾਈਮ ਲੰਘ ਗਿਆ ਉਹਨੂੰ ਪੁੱਛਿਆ ਕਿ ਬਈ ਇਹ ਕਿੱਥੇ ਲੈਟਰ ਲਿਖ ਕੇ ਭੇਜਿਆ ਇਨ ਰਾਈਟਿੰਗ ਜੀ ਤੁਸੀਂ ਤੇ ਬਣ ਚੁੱਕੇ ਹੋ ਜੀ ਪਰਮਾਨੈਂਟ ਰੈਜ਼ੀਡੈਂਟ ਆਫ ਦਾ ਯੂਨਾਈਟਿਡ ਸਟੇਟ ਤੁਹਾਨੂੰ ਆਪਣਾ ਕੀ ਕਹਿੰਦੇ ਕੋਈ EAD ਕੁਛ ਨਹੀਂ ਚਾਹੀਦਾ ਹੈਗਾ ਬਸ ਤੁਸੀਂ ਵੇਟ ਕਰੋ ਤੇ ਤੁਹਾਨੂੰ ਆ ਜਾਏਗਾ ਜੀ ਕਾਰਡ ਆ ਜਾਏਗਾ ਸਰ ਜੀ ਕੋਈ 6 ਮਹੀਨੇ ਦੇ ਬਾਅਦ ਉਹਨਾਂ ਨੇ ਜਨਾਬ NTA ਇਸ਼ੂ ਕਰ ਦਿੱਤਾ ਜਨਾਬ ਕੋਰਟ ਦੇ ਵਿੱਚ ਜਾਓ ਤੁਸੀਂ ਤੇ ਪ੍ਰੋਸੀਡਿੰਗਸ ਚ ਹੈਗੇ ਹੋ ਸਰ ਉਹ ਪ੍ਰੋਸੀਡਿੰਗ ਚੱਲੀਆਂ ਸਰ ਜੀ 5-6 ਸਾਲ ਹਾਂਜੀ ਉਹ ਅਪਹੈਲਡ ਕੀਤਾ ਹਾਂਜੀ ਤੁਸੀਂ ਜਨਾਬ ਰਿਮੂਵੇਬਲ ਹੋ ਉਥੋਂ ਸਰ ਜੀ BIA ਚ ਗਿਆ 2-3 ਸਾਲ ਹੋਰ ਲੱਗੇ ਅਪਹੈਲਡ ਕੀਤਾ ਉਹਨਾਂ ਨੇ ਵੀ ਜੀ ਹਾਂਜੀ ਕੀ ਹੈ ਸਰ ਜੀ ਫਿਰ ਲਾਸਟ ਜਿਹੜਾ ਰਿਜ਼ੋਰਟ ਸੀਗੀ ਇੰਤਹਾਈ ਉਹ ਕੰਜ਼ਰਵੇਟਿਵ 8ਵੇਂ ਸਰਕਟ ਦੀ ਕੋਰਟ ਹੈ ਉੱਥੇ ਅਸੀਂ ਦਾਦ ਫਰਿਆਦ ਲੈ ਕੇ ਗਏ ਕੋਈ ਐਕਸਪੈਕਟ ਨਹੀਂ ਸੀ ਕਰ ਰਹੇ ਕਿਉਂਕਿ ਉਹ ਤਾਂ ਬੜੀ ਕੰਜ਼ਰਵੇਟਿਵ ਕੋਰਟ ਹੈ ਸਰ ਜੀ ਉਹਨਾਂ ਨੇ ਸਵਾਲਾਂ ਦੀ ਪੁਛਾੜ ਕਰ ਦਿੱਤੀ ਆਇਲ ਦੇ ਉੱਤੇ ਕਿ ਬਈ ਕੀ ਹੋ ਰਿਹਾ ਜੇ ਹਾਂ ਕੋਈ ਬੰਦੇ ਤੁਸੀਂ ਇੰਨੀ ਗ੍ਰੋਟੈਸਕ ਬਲੰਡਰ ਕੀਤੀਆਂ ਕਿ ਨਹੀਂ ਕੀਤੀਆਂ ਕੀ ਹੋ ਰਿਹਾ ਲੋ ਜੀ ਉਹ ਓਰਲ ਆਰਗੂਮੈਂਟ ਦੇ 7 ਦਿਨਾਂ ਦੇ ਬਾਅਦ ਜੀ ਉਹਨੇ ਆ ਗਿਆ ਜੀ ਅਸੀਂ ਤੇ ਕਲੋਜ਼ ਕਰ ਰਹੇ ਹਾਂ ਅੰਡਰ ਮੈਟਰ ਆਫ ਬਾਕਾਵਾਨ ਐਵਿਟੇਜ਼ੀਆਨ ਸਾਨੂੰ ਇਖਤਿਆਰ ਹੈਗਾ ਅਸੀਂ ਅਪਲਾਈ ਕਰ ਰਹੇ ਹਾਂ ਐਡਮਿਨਿਸਟ੍ਰੇਟਿਵ ਕਲੋਜ਼ਰ ਮੈਨੂੰ ਕੁਝ ਪਤਾ ਨਹੀਂ ਸੀ ਹੁੰਦਾ ਮੇਰਾ ਮਕਸਦ ਇਹ ਸੀ ਕਿ ਵੀ ਪ੍ਰੋਸੀਕਿਊਸ਼ਨ ਜਦ ਸਰੈਂਡਰ ਕਰਦਾ ਪਿਆ ਜੇ ਔਨ ਬਿਹਾਫ ਆਫ ਅਟਾਰਨੀ ਜਨਰਲ ਆਫ ਦ ਯੂਨਾਈਟਿਡ ਸਟੇਟ ਦੈਟ ਮੀਨਸ ਖਤਮ ਹੈਗਾ ਸਾਨੂੰ ਉਹ ਦੇ ਦੇਣਗੇ 551 ਦੇ ਦੇਣਗੇ ਔਰ ਉਹ ਪਾਸ ਹੋਏਗਾ ਮੈਨੂੰ ਇਹ ਵੀ ਕਿਹਾ ਉਸ ਵੇਲੇ ਵਕੀਲ ਨੇ ਹਾਂਜੀ ਤੁਹਾਨੂੰ ਮਿਲ ਜਾਏਗਾ ਲਓ ਜੀ ਉਹ ਕੀ ਦੇਣਾ ਉਹਦੇ ਬਾਅਦ 765 ਕੀਤਾ ਉਹ ਵੀ ਰਿਜੈਕਟ ਕੀਤਾ 131 ਕੀਤਾ ਯਾਰ ਤੁਸੀਂ ਉਹ ਦੇ ਦਿਓ ਉਹ ਵੀ ਰਿਜੈਕਟ ਕੀਤਾ ਕਰ ਕੇ ਮੈਂ ਕੁਝ ਸਾਲ ਪਹਿਲੇ ਦਫ਼ਤਰ ਤੋਂ ਗਾਈਡੈਂਸ ਲਈ ਤਾਂ ਉਹਨੇ ਕਿਹਾ ਜੀ ਆਪਣੇ ਤੁਸੀਂ ਸੈਨੇਟਰ ਨੂੰ ਲਿਖੋ ਔਰ ਸੈਨੇਟਰ ਨੂੰ ਵੀ ਲਿਖਿਆ ਸਰ ਕੁਛ ਨਹੀਂ ਹੋਇਆ ਉਹ 8 ਸਾਲ ਲੰਘ ਗਏ ਨਾ ਐਟਰਨਲ ਕਲੋਜ਼ਰ ਅਪਲਾਈ ਕੀਤਾ ਹੋਇਆ ਸਰ ਜੀ ਉਹਨਾਂ ਨੇ ਲੇਕਿਨ ਕੋਈ ਕਾਗਜ਼ ਵਰਕਾ ਕੁਛ ਨਹੀਂ ਜੇ ਉਹ ਦਿੰਦੇ ਹੈਗੇ ਸਾਨੂੰ ਬੱਚੇ ਜਿਹੜੇ ਸਨ ਉਹਨਾਂ ਨੇ ਬਸ ਡਾਕਾ ਫੇਲ ਕਰ ਲਿਆ ਲੇਕਿਨ ਉਹਨਾਂ ਦੀ ਕੋਈ ਸ਼ਾਦੀशुदा ਨਹੀਂ ਹੈਗੀ
ਅੱਛਾ ਇਹ ਦੱਸੋ ਡੂ ਯੂ ਹੈਵ ਐਨੀ ਅਮਰੀਕਨ ਬੌਰਨ ਚਿਲਡਰਨ
ਨਹੀਂ ਸਰ ਨਹੀਂ ਉਹ ਨਹੀਂ ਹੈਗੀ ਉਹ ਰਿਲੇਸ਼ਨਸ਼ਿਪ ਨਹੀਂ ਹੈ ਸਰ ਮੇਰਾ ਉਹਨਾਂ ਕੋਲ ਡਾਕਾ ਹੈ
ਅੱਛਾ ਤੇ ਤੁਹਾਡਾ ਜਿਹੜਾ L1 ਵਾਲਾ ਬਿਜ਼ਨਸ ਅਜੇ ਵੀ ਚੱਲ ਰਿਹਾ ਕਿ ਬੰਦ ਹੋ ਗਿਆ
ਸਰ ਉਹ ਆਪਣਾ ਸੀ ਬਿਜ਼ਨਸ ਉਥੋਂ ਲਾਹੌਰ ਤੋਂ ਇੱਥੇ ਉਦੋਂ ਐਕਸਪੋਰਟ ਕਰਨੇ ਸਾਂ ਉਹ ਕੰਪਨੀ ਇਨਕਾਰਪੋਰੇਟਡ ਹੈਗੀ ਹੈ, ਥੋੜਾ ਬਹੁਤ ਹੈਗਾ, ਉਹ ਨਨ ਪ੍ਰੋ ਟੰਕ ਹੁੰਦਾ ਜੇ ਉਹ ਕੀਤਾ, ਲੇਕਿਨ ਉਹਦੇ ਚ ਇਹ ਜਿਹਾ ਮਸਲਾ ਕਿ EMPLOYEE ਇਸ ਵੇਲੇ ਕੋਈ ਨਹੀਂ ਹੈਗਾ, ਉਸ ਚ ਚੱਲ ਰਿਹਾ ਜੇ ਉਹ ਇਨਕਾਰਪੋਰੇਸ਼ਨ ਤੇ ਹੈ ਉਹਦੀ ਕੰਪਨੀ ਦੀ। ਲੇਕਿਨ ਜੇ ਅਸੀਂ ਜਾਵਾਂਗੇ ਤੇ ਉਹਦੀਆਂ ਦੂਜੀਆਂ ਜਿਹੜੀਆਂ ਉਹ ਮੰਗਣਗੇ ਕਿ ਜਨਾਬ ਕਾਮਨ ਓਨਰਸ਼ਿਪ ਦੇ ਸਬੂਤ ਦਿਓ। ਉਹ ਹੁਣ 22 ਸਾਲ ਹੋ ਚੁੱਕੇ ਨੇ ਇਸ ਮਾਮਲੇ ਨੂੰ, ਉਹ ਦੇਣੇ ਬੜੇ ਮੁਸ਼ਕਲ ਨੇ। ਉਹ ਖਾਲੀ ਇਹ ਇਤਰਾਜ਼ ਨਹੀਂ ਲਾਉਣਗੇ ਇਹਦੀ ਹਾਲਤ ਚ, ਉਹ ਕਹਿਣਗੇ ਜੀ ਕਾਮਨ ਓਨਰਸ਼ਿਪ ਦੱਸੋ, ਉੱਥੇ ਦੀ ਜੀ ਐਕਟੀਵਿਟੀ ਦੱਸੋ, ਇਹ ਵੀ ਪ੍ਰੂਵ ਕਰੋ। ਉਹ ਨਹੀਂ ਮੰਨਣਗੇ ਸਰ, ਜੇ ਉਹ ਕੀਤਾ ਉਹ ਬੜਾ ਦੇਖਿਆ ਜੇ ਮੈਂ ਕਰਕੇ। ਤੁਸੀਂ ਨਾ ਕੁਛ ਨਹੀਂ ਦੇਣਾ।
ਤੁਸੀਂ ਇੱਕ ਕੰਮ ਕਰ ਸਕਦੇ ਹੋ, ਯੂ ਕੈਨ ਅਰੇਂਜ ਫॉर ਅ ਕੰਸਲਟੇਸ਼ਨ ਬਿਟਵੀਨ ਮੀ ਐਂਡ ਯੋਰ ਲਾਇਰਸ। ਜਿਹੜੇ ਲਾਇਰਸ ਨੇ ਤੁਹਾਡਾ ਕੇਸ ਆਲ ਦ ਵੇ ਟੂ 8th ਸਰਕਿਟ ਪਰਸਿਊ ਕੀਤਾ ਹੈ।
ਕੋਈ ਲਾਇਰ ਨਹੀਂ ਹੈਗਾ ਸਰ ਜੀ, ਮੈਂ ਤੁਹਾਡੇ ਨਾਲ ਕਰ ਸਕਦਾ, ਤੁਸੀਂ ਲੈ ਸਕਦੇ ਹੋ ਕੇਸ ਸਰ, ਮੈਂ ਫੀਸ ਦੇ ਸਕਦਾ, ਮੈਂ ਕੰਸਲਟੇਸ਼ਨ ਤੁਹਾਡੇ ਨਾਲ ਅਰੇਂਜ ਕਰ ਲੈਣਾ ਜੇ ਤੁਸੀਂ ਇਜਾਜ਼ਤ ਦਿਓ, ਦਫ਼ਤਰ ਫੋਨ ਕਰਕੇ।
ਮੈਨੂੰ ਐਟਲੀਸਟ ਆਈ ਵਿਲ ਨੀਡ 1 hour ਵਿਦ ਯੂ। ਉਹਦੇ 'ਚ ਅੱਧਾ ਘੰਟਾ ਪੌਣਾ ਘੰਟਾ ਕਾਗਜ਼ ਰਿਵਿਊ ਕਰਨ ਲਈ। I just need to review the 8th Circuit opinion, and I need to review your BIA opinion against which you took the appeal. So those two decisions I'll take a look at. I don't need to look at the other documents yet. If there is anything I can do, I will let you know. You can send me an email to help@immigration.com. I'll take a look at it, Ji.
ठीक है सर, मैं वो थानू डॉक्यूमेंट्स भेज देना एट योर कन्वीनियंस प्लीज सर, आई विल पे फॉर यू। लेकिन मैं वो कॉन्फ्रेंस भी ਤੁਹਾਡਾ ਟਾਈਮ ਲੈ ਲਵਾਂਗੇ, ਪਹਿਲੇ ਮੈਂ ਡਾਕੂਮੈਂਟ ਭੇਜਾਂ ਤੁਹਾਨੂੰ ਕੀ ਆ।
ਤੁਸੀਂ go ahead and send me the documents. I will to help@immigration.com. I'll have my office reach out and set up a consultation for 1 hour. ठीक है, मैं देख लेना।
ठीक है, बहुत बहुत धन्यवाद खाना साहब अपना, और बहुत शुक्रिया that you've been helping the community for such over a quarter century, sir. It has been greatly appreciated. God bless you. Be safe and well with the family and all friends.
Thank you ji, thank you ji, thank you ji. ਨਾਲੇ ਸੁਣਿਆ ਕਿ ਜਿਹਨੇ ਲਾਹੌਰ ਨਹੀਂ ਜੰਮਿਆ ਉਹ ਤੇ ਜੰਮਿਆ, ਉਹ ਜਿਹਨੇ ਦੇਖਿਆ ਉਹ ਜੰਮਿਆ ਹੀ ਨਹੀਂ। ਸਾਡੇ ਵਾਲਦ ਸਾਹਿਬ ਇਹੀ ਕਹਿੰਦੇ ਨੇ। Alright ji. Next, let's see, area code 203243. That's Connecticut. Oh, 1 second. What happened? Oh, Connecticut, where did you go? I guess you hung up. Yeah, hello? Connecticut?
Yes.
Go ahead.
Yes. So, quick question. I went for F1 student visa in India, US Embassy, in around 2007. And first time visa was rejected. After 2 weeks, I booked another appointment for same, and the F1 visa got approved.
Good.
While filling out I-485 form, I misunderstood the question where it says, have you ever been denied a visa to the United States?
Okay.
And I have marked it as no. So is that correct understanding, or should it be?
Okay. So what you should do is, you should immediately make a service appointment and ask them this question. Make a note of the time and the date you called. Keep record of it. They'll probably advise you to correct the 485. There are a couple of different ways to do that. But first thing you should do is open a service request so that it should be clear that you try to correct that error. Okay. It is important that you do that. Okay. So open a service request. As soon as you hang up, you call the USCIS customer service. Okay. Good luck.
Okay. Thank you. Thank you.
Bye-bye. Okay, now we come to North Carolina. North Carolina, I can hear you. Please go ahead.
Hello, sir. So I have a case of duplicate H-1B registration. So there was a communication gap between my employer and the attorney. But one of the registration is picked, it's selected, and I also have the action of notice. But the USCIS portal states that in case of duplicate registration, the status should change to denied, but it is still not denied. So should I go ahead and continue with my H-1B petition?
The answer is simple. Technically, they should have denied, but they have not denied. You can keep your fingers crossed, hope for the best. Absolutely apply for the H-1B. No question in my mind about that. Okay.
So would there be any repercussions in case later on during the petition they find out that there was like a duplicate registration?
Keep in mind a couple of things. First of all, it's not your filing, it's your employer's filing. If anybody has done anything wrong, it's your employer and your lawyer, not you. Okay? So there should be no repercussion on you, number one. Number two, the maximum they can say is no, right? They can deny your H-1B. It should have no blowback on you. That's my opinion. All right? Sir, you're going to have to be quick on your feet. Yes or no? Good?
Yes.
Excellent. Good luck. Okay. Let's go on to the next question. This one is from Florida. Area code 904. 904, I can hear you. Go ahead, please.
I am currently on F1 visa, and I'm working on my STEM-OPT. I'm working right now, but my STEM-OPT expires June 27th of this year.
Okay.
And I'm applying for my master's for the 1 CPT, which will start in July.
Okay.
So for my admission application, they are asking for from I-134, which is the affidavit of support. So there is a portion that says beneficiaries anticipated length of stay, and it's asking for from date and to date. So I'm confused of what date to put there.
So there are two ways to handle this. I'm not sure how other people do. You should begin by calling your DSO. Okay. Your school, designated school official should be able to tell you how to fill that I-134. The way I see it, you can do one of the two ways. You can either put just DS on both begin and start date, or you can put the date your school, DS is duration of status, DS, or you can actually just put the date your school starts, your classes begin, and the date your classes end plus 60 days.
Okay.
That's what I would do. One of the two options. But I would rather have you talk with your DSO and see what they suggest. Okay?
All right. All right. Thank you so much.
You're welcome. Good luck. Okay. Let's go on to the next question. This one is from... Oh, this is from Virginia. Area code 571. 571, I can hear you. Go ahead, please.
Hi, sir. My 485 has been pending, and I have been offered a promotion at my work, and my work duties do not change more than 50%. I already postponed this promotion, saying I'll wait for a month to see if I get
Okay, hold on one
second.
second.
Not happen.
Hold on one second. Sir, hold on one second. So, can you tell me the job titles? Which title are you going from and to?
I'm a senior. I'm going to lead in the same field.
Senior to lead. So let's say senior software developer to lead software developer. Okay. So your I-140 is approved. Your I-140 is approved, right?
By one. Yes.
And your 485 has been pending more than 180 days, right?
Yes. Since May 2020.
This is very easy. Just do a supplement J for the new job. You're good.
Okay. Yeah, that was my follow-up question actually.
Yeah.
Is that all I need to do, supplement J?
Just a supplement J. It's a very easy.
Will that adverse?
No adverse impact.
Okay.
It's a
will
very...
that affect me?
No. It should be fine. Go for it. Okay.
Okay, it will not delay my GC.
Well, it can delay. I mean, they are going to adjudicate the supplement J, but why should you forego a promotion? There's no way to know what will happen as far as your green card is concerned. So, might as well take the promotion.
Yeah.
Okay.
Because recently mine went to SRC Texas Center and they recently moved to NBC just 1 month back. So, I just don't want to take any risk and just get the GC first.
Well,
So
I also think that you could take a more aggressive strategy and wait till September to file your supplement J. Once October 1st comes and your case is not approved, file the supplement J.
Okay, until then, don't take the promotion, you're saying?
You can delay the promotion or you can take the promotion and not file supplement J. Because there is, see...
Our attorney was pushing to file supplement J if you take the promotion.
No, I disagree. I'll tell you, I think you can set up a call. I can have a conversation with your lawyer. We can talk about it and come up with a plan that is reasonably safe for you. Okay? I think it can be done without a supplement J. Yeah, no problem at all. Okay?
All right.
Good luck.
Thank you.
You're welcome. Yeah, sometimes what happens is corporate lawyers are overly cautious, and I can understand that. They are trying to protect the company, but this has no harm on the company. So I can talk with them, see what they think. New Jersey area code 973. Go ahead, please. 973.
Hello, sir.
Hello, sir.
How are you? So my situation is we did EB3 downgrade in November 2020.
Okay.
And my attorney checked the financials of the employer. I don't work with them anymore.
Okay.
So they sent the withdrawal request.
Hello? Oh,
so
sorry.
Now,
okay.
Hello?
Yeah, now I can hear you. Go ahead.
Hello, sir?
Okay.
I can. Sure. Yeah. So we did a EB3 downgrade in November 2020, and we sent the withdrawal for that. After a few months checking the financials. I don't work with that employer anymore. Now what's happening is we wanted to just wait for the RFE from USCIS, and we wanted to say that the withdrawal we sent, they did not process the withdrawal till now, right? It's been more than 1 year. So our plan was when RFE is sent, we wanted to say okay, we sent withdrawal, please don't process this, right? I have a EB2 approved already. Now the date is current for EB2, and USCIS sent us an email saying we are recommending the interfiling with EB2. Now, with my situation, am I eligible to do the interfiling? I don't want EB3 I-140 to be processed.
No. Do the EB2. Don't do interfiling, because what if the I-140 doesn't get approved? I mean, you already sent a revocation for that, right? So how can you do an interfiling? You don't even work for that employer anymore. No. I don't think you can do interfiling.
Okay. Even though I have the EB2 I-140 approved with the same employer.
With the old employer, not the... I thought you had an EB2 I-140 with the new employer, EB3 with the old employer.
No. Both are with the old employer only.
Okay. So both... Hang on.
I'm not working with...
Let me get this. You have two petitions filed through the same employer. One was EB3, one was EB2. EB3, you sent in a withdrawal. It's still pending. EB2 is approved. Correct?
Yes.
Okay. So, did you file a 485 or not yet?
Yes, with EB3 as concurrent filing. Yeah.
Okay. But you are not with that employer anymore. You moved on.
No.
Are you planning to go back to that employer?
Maybe if my 485 is approved, I can go.
You can talk with your lawyers and see if it is possible to do an interfiling. If you want to go back and join them and they have the job open for you, listen to the frequently asked questions we've been talking about last few weeks. This issue has come up many times in different ways. I think it might be possible to file for interfiling based upon the intention to join them back and their intention to hire you back. Okay?
Okay, but even though my EB3 I-140...
No, I would not. Sorry, let me rephrase that. I would take the EB3 based 485 and move it to EB2.
Okay, but what if they accept the interfile? Will they process the EB3 I-140? I don't want that.
No, they shouldn't. I don't think they should, because you already withdrawn that. What you are doing is you are interfiling from EB3 to EB2. Because you have a 485 pending with the EB3, which is to be revoked. See, the problem is, actually, I just changed my mind again. What happens is, when you apply for revocation, even if the government acts on the revocation 2 years later, it can relate back to the date of the filing. Why don't you just file a new 485 through the old employer? That could work.
So, but with the EB2, right? Okay. Yeah, but that's a cost for me. Okay.
Yeah, I think that's the safest thing. I would not want to, no sense in any adventures here. I think EB2 485 is the safest thing.
Okay, right. Sir. Thank you so much.
You're welcome. And this one is from Texas. Texas, I can hear you. Go ahead, please.
Hi, Rajiv ji. Good morning. So my doubt is that currently I'm on my STEM-OPT extension. I got my EAD card last November, effective from this January. But I recently observed that my last letter of my first name is truncated or dropped from my EAD card. It's the same on my approval notice too. Recently, my F1, lottery for H-1B got picked, and I'm sending this document as well for processing. My attorney told me that if I might get an RFE for this. So my doubt is that if I get an RFE, and I go in normal processing, right? So in that case, will they give me enough time for me to submit the document, or because it's normal processing, they might give less time or such things like that?
No, they should give you the same time as they do normal people normally, which is 87 days. But it is, of course, within their right to give you 2 weeks or 3 weeks. But also remember that any RFEs received till July of this year will have an extra 60 days grace period to respond, no matter how much time they give you.
Oh, okay. So in that case, premium processing will be better option, right? Like if I get an
I generally think premium processing is a better option, sure. Okay. By the way, I want to add to people who are just joining, I will not be answering any new questions. I had selected 9. I'm going with the 9 that had been selected. So if you have just joined, no, I'm not talking to you. I'm just talking.
So what is the probability for these?
Hang on, sir. One second, sir. People who are just joining, I will not be answering new questions. I'd already selected 9 questions. That's all I'll be answering. Sorry. Yeah, sir. What you were saying? Go ahead, please.
Yeah. So what is the probability of this getting an RFE, that one letter of my first name?
See, why do you get bothered by the RFEs? They are a fact of life. Why? How does that matter? You have an explanation. You are not responsible if their database developers have created a text field with 11 characters and you have 12 characters in your name. That's not your fault. I don't see why that should be a problem.
Okay. Yeah.
Okay. That's a database issue. They should have planned better. Their databases should be better. Okay.
Okay. Yeah. Thank you.
Good luck. Okay. Now, guys who are just logging in, I'm reminding you, this is the last question I'm answering. No more questions after this. This is from India. And they've been waiting 1 hour, 20 minutes. So I better get to their question. India, I can hear you.
Hello.
Yes, ma'am.
Yeah, that was me calling from the other number because this call is going to drop in like 1 minute.
No worries. Tell me, how can I help you?
Okay. So I am a dentist from India and I have a B1, B2 visa.
Hanji.
I'm applying to dental schools in the USA and to make my profile better, I was just looking at some 1-year fellowship programs, but they offer a J1 visa.
Ooh.
So will it be a problem if I change my J1 to H1 later?
Just make sure that the J1 doesn't have a home residency requirement.
Okay.
Do you know what that is?
How do I get to know about that?
Do you know what that is?
Yeah, I did read about it.
Okay.
Yeah.
So many J1s, because they are funded by the US government directly or indirectly, or because you are on a list that your home country wants to have in the country rather than out, it's called the skills list. So because of one of the 2 reasons, you can be required to go back to your home country. It's also called Section 212E as an elephant condition or requirement. So HRR, which is home residency requirement, or 212E, if it applies, you will not be able to. Oh, I think India got dropped off. Ma'am, I'll record this so you can hear it later. So you have to make sure that your 212E does not apply. How do you make sure? You ask the program sponsor. And also, when they issue the DS 2019, which is the form for your J1, this is not a 100% proven rule, but the general rule is if your program number begins with prefix G as in government, it probably will have the 212E requirement. And if it begins with P as in private, it might not. So that's the general rule. I hope you can listen to this recording, but that's the only thing I would worry about. Folks, as I said, I would only be answering questions for the people who had raised the hands when I asked for it. There were 9 of them, and actually a 10th one raised in the middle of the conversation. I answered all those questions. The rest of you folks, I'll talk again in 2 weeks. Take care, guys, and always good to talk to you. Bye-bye.